Welcome to Limits Exhausted, Texas's personal injury litigation podcast.
Hey everyone, welcome back to an all-new episode of Limits Exhausted, Texas Injury Litigation Podcast with attorney Kiernan McAlpine, the founder of McAlpine Law Firm and a board-certified specialist in personal injury trial law by the Texas Board of Legal Specialization. I am your host, Mike Leon. Kiernan has tried more than 40 cases to verdict and is frequently brought in by other attorneys to handle complex, high-exposure litigation involving 18-wheelers, catastrophic injuries, and even wrongful death cases. Today's episode, we're going to be talking about the aforementioned wrongful death cases in the state of Texas and what truly drives case value versus what often gets overstated early on in the case. Kiernan, it's good to see you as always. This has got to be a tough subject just to talk about because obviously somebody has passed away with respect to these cases. When you first evaluate a wrongful death case, what factors tend to kind of matter most in determining whether the case does have, like I mentioned, that true high exposure potential?
Yeah, thanks for having me, Mike. Really appreciate it. This is a fascinating topic. And my biggest jury verdict to date was a $6.85 million verdict on a wrongful death case in Beaumont. It's something that I do have experience settling and trying these cases. And wrongful death cases can be gnarly for the lawyer representing the bereaved family for a lot of reasons. It's a difficult type of case emotionally for the client, and it's also a difficult kind of case to work up for trial, and it's a difficult kind of case to evaluate. So I'd say that probably, just brass tacks, low-hanging fruit, right? The most basic indicator that you would have a very high potential for a case would be one where you have somebody who's a breadwinner, somebody who is a good income earner, who's also relatively young. If you have a significant future loss of earning capacity damages model, which you can only prove up through an expert witness who you'd have to hire and get a whole bunch of information about what their income was and what their vocational ability was and what their work history was, and model out their future loss of income, future loss of benefits to their family, future retirement income, things like that. All of that has to be tabulated by an expert in that. And that gives these cases something that they often don't have. Like, for example, when we're dealing with catastrophic injury cases that involve like a brain injury or, a spinal cord injury, you're going to have a lot of past medical bills and you're going to have a lot of future medical bills related to lifetime care for the injured person. You don't have any future lifetime care for somebody who's deceased, unfortunately. So you have the survival claim that does have the past damages, but the element of economic damages that's a real hammer in these kind of cases comes from loss of earning capacity in the future that the family wouldn't have access to because of what happened. So I'd say that's the biggest red flag for a large death case.
Let me ask you, wrongful death versus non-fatal injury cases, like how does the underlying liability picture kind of influence the case value with respect to wrongful death versus obviously somebody that has survived the injuries?
I'm tempted to say that it doesn't, but that isn't true. Where I come down on this is that there's a major logistical issue that the lawyer has in a wrongful death case in terms of proving liability, which is that they do not have access to their client as a witness to testify about the occurrence. All right, unless somebody passes away, as a result of complications, some amount of time after you've been able to get their statement, after they've possibly been deposed in a case, then you would have access to them. But if you have somebody that passes away quickly as a result of the tragedy that happened, we don't have access to their testimony. So we have to be able to prove up the case through documents, corroborating evidence, as well as, admissions from witnesses that are under the defendant's control. So it makes litigation way more important. We're forced to prove up the case almost to a higher evidentiary standard simply because we need to be able to elicit favorable testimony from hostile witnesses and prove up the case brick by brick with documents rather than simply relying on plaintiff testimony to fill in the gap. So I'd say that makes a very big logistical difference. But by the same token, those are the kind of things that a lawyer should be doing basically in every case. It shouldn't be leaning 100% on your client to tell the story. You want to get the good deposition testimony. You want to get the documentary evidence. You want to get the corroborating witnesses and so forth. So it on the one hand, it creates an immediate logistical task for you, but you work up the case to a high standard and it comes out in a similar way. Also, these cases do sometimes involve like very aggravated circumstances, like negligence that would lead to somebody dying. It just smells more like negligence to gross negligence when there's a fatality involved. So it can be easier in that limited sense.
Yeah, it's got to be tough. You use the word gnarly, and I would kind of echo that, just in terms of the experience. Let me ask you specifically and personally, obviously, without sharing any intricate details, can you kind of walk us through a past wrongful death case, and maybe within the case, was there something that maybe initially seemed secondary, but it had a major impact on how the case was valued or even tried?
Yeah. So one of the things about these cases is the value of a death case in many circumstances is going to be almost totally non-economic damages, things like loss of companionship in society and male anguish. And the people who are going to have sustained those damages are going to be the wrongful death beneficiaries by statute, the surviving parents, spouse, children. And those individuals' relationship to the deceased and the quality of their relationship, how much contact they did or didn't have, how close they were, how much of the family members would rely on the deceased for support. Those kind of things really affect the way a jury perceives loss of companionship in society and male anguish. Like an estranged child versus a child that, is speaking to their mom or dad every day, a jury is going to look at those differently. And it can be difficult for a lawyer who has multiple claimants to suss out sort of whose claims are more valuable. But that's one thing that we've learned from trying these cases is that juries care about the interpersonal element of these damages, and they do care quite a bit about the relationships between the individuals and the deceased in terms of how much companionship or society has been lost or how much mental anguish has been sustained. So that it's not necessarily something that would scream out at you because these cases do have a certain amount of like common sense or, boneheaded obviousness about it in the sense that, well, somebody died. Of course, there's going to be mental anguish. Of course, there's loss of companionship or society. Always. Isn't there always? Well, that's not really how juries that are asked to put a specific dollar figure on these damages are going to look at it. It's a little bit more personal than that.
Yeah. Let's expand a little bit more on juries. In the state of Texas, you were talking a little bit about how they tend to respond to these, but like, what are some misconceptions that attorneys sometimes have about how these claims are evaluated, presented to the juries, and how do the juries respond to these wrongful death damages? In your experience, how have you seen them respond?
Sure. So the biggest misperception on the whole, and I think this would be something that like younger lawyers might be a little bit more prone to, is just the assumption that a wrongful death case is automatically a big case. Without close relationships or without a significant amount of future loss of earning capacity, these cases have values that can be highly variable. So I would say that don't assume if you've got one of these cases, but you're not experienced working them up, that because somebody died, that it's automatically going to be large. It may very well be large, but the ways that are necessary to make it large might be somewhat outside of your wheelhouse if you're not accustomed to working on these cases. I mean, if there's any case that I think ought to be handled by an attorney experienced trying these cases, it's a wrongful death case, simply because handling the non-economic damages element of it and handling the liability litigation needs to be done by an experienced person, in my opinion. So I would just say that it may very well be a big case, but don't assume that it's automatically a big case just because somebody has died, because there's necessary steps to prove it out that may not be completely obvious. Additionally, I would say that, yeah, I mean, I think that that's probably the biggest one. The next one would just basically be that there's a lot of skill and trial advocacy that goes into making juries appreciate the severity of non-economic damages, which is what these cases are ultimately going to be about. If you've got a lawyer who isn't highly experienced at arguing in front of a jury for significant amounts, millions of dollars of non-economic damages, tens of millions of dollars, of non-economic damages. It's a very different experience than arguing about medical treatment and medical bills. So, to the extent that those aren't a part of the case or they're not a big part of the case, it's just it's simply a different animal and a different skill set to argue for significant non-economic recovery.
Yeah. Let me ask you about defense teams for a second. I'm sure you've seen this, and you can correct me if I'm wrong. Like they attempt to reframe wrongful death damages. How have you seen them do that? When they do that, where do those strategies start to maybe lose some effectiveness?
Sure. So one of the things that they'll typically do is they'll look at kind of the life expectancy of the deceased, what their health was like. Like the case that I tried and got the near $7 million verdict on in Beaumont, that case, there was an exhibit in the case, which was a 14-page list of pre-existing conditions, not a 14-page medical record that contained pre-existing conditions, a 14-page list of pre-existing conditions. So the plaintiff's health the decedent's health in a comprehensive sense is going to be a factor when it comes to determining what their life expectancy is. And they will argue that stuff. And they will argue that there are comorbidities or other things that would have caused the person to pass away. But I think that these cases have a lot of moving pieces and there's a lot of judgment calls for the defense to make. I think they're somewhat difficult cases to try because for the defense as well as for the plaintiff, because there's a certain amount of just human instinctive sympathy and empathy for somebody who's lost a loved one as a result of conduct that's negligent or is arguably negligent or grossly negligent. So they have a somewhat difficult task. And I think that the more that they try to beat up the plaintiffs, the family members, beat up the decedent and try to minimize damages the way they might do it in like a regular car wreck case, for example. I think those things tend to really backfire in some of these cases. And the more that they're willing to make concessions and argue for a different number than what the plaintiff has asked for, I think that tends to be kind of effective when they do that. Like when they show up in trial in a death case and say, the plaintiff is asking for X dollars. Well, we don't think that's fair, but, they should get Y dollars as long as what they're advocating for is within the range of reasonable. I think that it does have an impact on how juries look at it. Like they have to try to look reasonable. If they don't, then they could be in a lot of trouble.
Right. Kieran, as we kind of wrap on today's episode, for the attorneys out there that are listening, maybe they're considering whether or not they should refer the wrongful death case out, right? What are some early indicators that you would advise them, or at least would suggest that the case is going to require that deeper trial preparation rather than just some type of routine negotiation?
I would say in full candor, Mike, all of them. Basically, in other words, if you aren't accustomed to working on wrongful death cases, you should refer the cases. Unless you're, trying to get better at doing them, in which case you should partner with somebody else that's done them. These are all cases that have potential exposure that's higher than what the policy limit is in almost every case, because you're dealing with the deaf, because you're dealing with, consortium claims and loss of companionship in society and middle language claims that have more gravity to them than you might see in another case. So every single one of these cases is potentially a big case, but it might not be, and it's going to depend on how it's handled. So it's something that is needing expertise to work on. So I would say that all of them are in that category where refer it or don't. It's your case, it's your business. But the fact is you should definitely talk to some people about it that have done these cases, that have won verdicts on these cases, and, sort of see what they think about it and potentially consider joining forces with a lawyer like that, like myself, that has done these, because there's a lot to these cases and there's no such thing as a routine wrongful death case.
Yeah. I was just going to say, I'm talking to one right now. So, Kieran, thank you again for the time and the insights and kind of breaking this down for the audience. I appreciate it, my friend.
Absolutely. Thanks, Mike.
That's it for today's episode of Limits Exhausted, Texas Injury Litigation Podcast. If you want to learn more, you want to connect with Kiernan and the team over at McAlpine Law Firm, do me a favor, visit McAlpineLaw.com right now. And one more favor, as always, before you head out the door, like, subscribe, leave a review, comment, share the episode with someone who needs to hear it. I am Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.